In this next section, we're going to cover bankruptcy. And generally, I think we're all familiar with filing bankruptcy, but there's a lot of little rules and different types of bankruptcy we may not be familiar with. The Constitution allows the federal government jurisdiction over bankruptcy. Congress has the power to establish uniform laws on the subject of bankruptcies through the U.S. So bankruptcy is generally a creature of federal law, but there are state variances between bankruptcy. The first bankruptcy in the U.S. was enacted in 1800, but then only creditors could begin a bankruptcy proceeding. So not the debtor, the creditor had to start the bankruptcy, and only merchants could qualify as debtors. In 1840, the debtors' prisons were abolished. Before 1840, you could go to jail because you were a debtor, but no longer. The Bankruptcy Reform Act of 1978 makes it easier for businesses and individuals to obtain bankruptcy relief. In 1978, Chapters 11 and 13 of the Code were created, which allow businesses and individuals to reorganize and keep going. The first bankruptcy provision we're going to discuss is Chapter 7. And Chapter 7 is probably the one that you think of when you think of bankruptcy. It's a liquidation bankruptcy. Basically, the debtor sells everything, pays as much of their debts as they can, and the rest are discharged. So that is what you think of. These are the other types of bankruptcy. So Chapter 7, of course, is what we just talked about. It's a liquidation bankruptcy. It's used when a debtor wants to discharge most debts and start over. The Chapter 11 reorganization is used by individuals, partnerships, and corporations. It's used when a debtor wants to continue operating but needs to reorganize and liquidate debt. So Chapter 11 is a reorganization type business bankruptcy where the owners of the business want to keep going, but they need to be able to reorganize some debt to do so. This one has to be approved by creditors. Chapter 12 is similar, except it applies to the family farm or a family fishing business. And it's also a readjustment plan to readjust and keep going. Chapter 13 is similar, but it's for individuals. So it's not a business bankruptcy, it's an individual bankruptcy. But again, this is used when an individual debtor who is working wants to just adjust the terms of their debt, perhaps, instead of discharging and losing everything. So under Chapter 7, to file and qualify for a Chapter 7 bankruptcy, a debtor must do all of the following. Satisfy the means test, and we'll define that later. Take an approved nonprofit budget, credit, and debt counseling course before filing for bankruptcy. Provide their federal income tax return for the most recent tax year. And take a course in financial management after filing for bankruptcy. Under the BAPCA, which is the Bankruptcy Abuse Prevention and Consumer Protection Act, a debtor can be disqualified from a Chapter 7 bankruptcy if they do one of the following. So they might want to file for bankruptcy, but they are not allowed to if they defraud a creditor or an officer of the estate, they fake documents that record the debtor's business or financial dealings, they disobey a court order, they do not explain the loss of assets that would have empowered the debtor to meet his or her liabilities, or they have received a Chapter 7 bankruptcy discharge within the last 8 years. So remember, to file for Chapter 7, I said that a debtor has to satisfy the means test. Well, this is the means test. They compare the debtor's average income during the previous 6 months with the median income for a family of that size in the debtor's state. And debtors are required to determine whether they have enough income to pay off some of their unsecured debts. If the debtor's income is less than the state's median income, the debtor is eligible to file Chapter 7 bankruptcy. Every state's median income is available online at the U.S. Census Bureau website. And to determine that disposable income, the determination requires subtracting the expenses that a debtor would be expected to spend on food, housing, utilities, clothing, out-of-pocket health care, transportation, housekeeping supplies, personal care, and some miscellaneous items from the debtor's actual income to arrive at a figure called disposable income. That disposable income is going to determine whether or not they can file a Chapter 7. If that disposable income is less than $100 a month, they pass the means test and they can file a Chapter 7 bankruptcy. If it's more than $167 a month, they fail the means test. And a determination is made as to whether the debtor has the ability to pay the unsecured debts over a 5-year period. So if the debtor's monthly disposable income is between $100 and $183, but not enough to pay more than 25% of the outstanding unsecured debts over a 5-year period, the debtor passes the means test and will be eligible to file for a Chapter 7. But if the disposable income is enough to pay those debts over 5 years, the debtor cannot file for Chapter 7. And their only option then is to go into a Chapter 13, which remember was a reorganization. So debtors can choose voluntarily to file a Chapter 7 bankruptcy proceeding, but also creditors can involuntarily force a debtor into Chapter 7 bankruptcy. So to do that, the creditor must prove that the outstanding debts are not subject to a bona fide dispute, and a single creditor who is owed a debt of more than $14,425 can file if the debtor has fewer than 12 creditors. But if the debtor has 12 or more creditors, 3 of them must join together to file the petition, and that combined debt owed by the 3 must exceed that $14,425 number. This amount is adjusted every 3 years to reflect changes in the Consumer Pricing Index. Okay, once we have a filing, the bankruptcy petition itself becomes the order for relief and is effective the moment it is filed with the court. And an order for relief is the court's command that the liquidation begin. In the case of an involuntary filing, the court does not issue an order for relief immediately because the debtor is allowed to contest that filing and have a hearing to determine if an order for relief will be granted. After we get the order for relief, we have an automatic stay. And an automatic stay is a self-operating postponement of collection proceedings against the debtor. It says that further efforts to collect debts of the debtor must stop immediately, except for debts caused by fraud, amounts owed for back taxes, family support, and student loans that do not impose a hardship on the debtor. The automatic stay applies to both voluntary and involuntary petitions, and creditors who knowingly ignore that stay can be held in contempt of court. So that automatic stay really is like a gate coming down. Once that comes down, creditors have to stop trying to collect, and if they don't, they can be held in contempt of court. That stay is going to prohibit creditors from beginning or continuing lawsuits to collect debts incurred before the filing of the petition, any attempts to enforce a judgment against the debtor, any foreclosure sales, any collection proceedings, and any repossession activities. During the course of a Chapter 7 bankruptcy, there are some exemptions, and these are things that won't be sold to satisfy debts. There are exemptions provided by the federal government, and there are exemptions provided by the state government. And in most states, not all, but in most states, a debtor gets to choose whether they want to use the federal exemptions or the state exemptions. So under the federal exemptions, the household exemption is going to allow the debtor to keep a maximum amount set by law in equity in the debtor's place of residence and in property used as a burial ground. The federal exemptions also allow debtors to keep up to $550 worth of any single item of furniture, household goods, clothes, appliances, books, crops, animals, or musical instruments. The total of all of those exemptions can't exceed $11,525. Debtors may also keep up to $1,450 in jewelry beyond the $9,850 set aside for the other household items mentioned above. In addition, they may keep any other property not exceeding the value of $1,150 plus up to $10,825 of any unused amount of the $21,625 homestead exemption. All right, and like I said, state exemptions are dollar amounts included in state statutes They will be a more accurate assessment of property values within each state, and they can be more or less favorable. If you're familiar with Texas, you know that generally your home, no matter the value, there are some limits, but generally your home, no matter the value, is exempted from being taken into bankruptcy. So people in Texas generally use the state exemptions rather than the federal exemptions. In a bankruptcy, there's a trustee, and a trustee sets aside certain sales and property transfers made by the debtor. So if right before you file a Chapter 7 bankruptcy, you give away a bunch of your property, say to a family member, or you sell a bunch of stuff, the trustee has the power to void those. So set aside, pretend like those didn't happen, and recover the property. The trustee also has the duty to sell the property and obtain cash. So they liquidate the estate, they sell everything except for the exemptions mentioned previously, and they gather all the cash. The trustee then distributes the cash among the creditors according to set priorities, so according to their order of priorities. And these are the order of priorities. So first, they distribute the cash to secured debtors. And we talked about security interest in the last chapter, so creditors with security interest get to take their collateral first. So anything they hold a security interest in, they get to take. Next, it's domestic obligations, so maybe child support, spousal support, something like that. Third is expenses of the bankruptcy. Next is certain unsecured debts. Next is wages. Employees are paid next, and a maximum amount is set for each employee. Next is contributions to a benefit plan. If I am a business owner and I owe contributions to a benefit plan, those are made next. Next, deposits and advances. So deposits made for purchase or lease of property are paid next, as are advances made for personal, family, and household services. Next are taxes, death or injury claims, any remaining unsecured creditors, and then if there is any cash left over, it'll go back to the debtor. Now, as you can imagine, there's probably no cash left over, and probably in the case of a bankruptcy, we're probably not getting through the first 4 obligations before we're out of money. Okay, and then generally once the trustee has paid out all the cash, all the remaining debts are discharged. That's how a bankruptcy works. However, there are 3 exceptions. Any debts created by misconduct, any debts enforced by the government, and any debts created by excessive spending are not discharged. A bankruptcy filing is going to remain on the debtor's credit report for 10 years, and so as you can imagine, that's not great for credit, so it does make it hard to obtain credit in the future. But filing bankruptcy does give most debtors an opportunity to start over, and generally, someone who is in the position of filing bankruptcy probably doesn't have great credit anyway. So bankruptcy is usually it feels like a really great relief to debtors, individual debtors. So that was Chapter 7. That's a liquidation bankruptcy where generally the trustee collects all assets, sells all assets, and pays off debts in the order of priority. Everything else is generally discharged. The next type of bankruptcy is a Chapter 11 reorganization. This is a business reorganization. It provides a method for businesses to reorganize their financial affairs and still remain in business. A qualified debtor will create a plan that alters the repayment schedule. It's also called a reorganization. This is available to sole proprietorships, partnerships, and corporations. It can be voluntary or involuntary. One special feature of a Chapter 11 bankruptcy is a debtor in possession. So rather than turning everything over to a trustee like we do in a Chapter 7 bankruptcy, the debtor stays in possession and control of the assets because, remember, the goal of this bankruptcy is to reorganize but stay in business. So we allow the debtor to continue operating the business during this bankruptcy. But if problems of the business have been caused by poor judgment, mismanagement, or dishonesty, a trustee may have to step in and be appointed. So a reorganization plan in a Chapter 11 must follow these steps. So there is a creditors committee. which is appointed to investigate the operation of the business and assist the debtor in possession in developing and administering a reorganization plan. The plan must be fair, equitable, and feasible in the creation of the reorganization plan. And there must be plan approval by impaired classes. And impaired classes are those creditors who are not going to receive full repayment of what they're owed. So the plan must be approved by at least one impaired class, and more than half of the creditors who hold at least 2/3 of the amount of allowed claims in each class must accept the plan before it's approved. In addition, in the case of individual debtors, the plan cannot be confirmed over a creditor's objection without committing all of the debtor's disposable income over the next 5 years. A Chapter 12 bankruptcy is a bankruptcy for a family farming business or a family fishing business. It's also a reorganization type plan. It must provide for payment of fixed amounts to the trustee on a regular basis over a 3-year period. It must make certain that all priority claims are paid in full, and it must not take more than 3 years to complete. Okay, and then finally the Chapter 13 plan is an individual reorganization type plan, so individual debt adjustment plan. Chapter 13 is open to sole proprietors as well as just wage earners, those whose principal income is from wages, salary, or commissions, but it is not open to stockbrokers or commodity brokers. Rather than selling the debtor's property, Chapter 13 of the Bankruptcy Code permits an individual debtor to put in place a repayment plan, and once the amounts agreed to under the plan are paid, all remaining debts are discharged.